The breaking Supreme Court news of the day is that the Supreme Court finally has new rules, which Clarence Thomas has already violated. Today, the Supreme Court issued an 8-page code of conduct for Supreme Court justices. One of the rules says that a Supreme Court justice should, quote, disqualify himself or herself in a proceeding in which the justice's impartiality might reasonably be questioned. That rule goes on to specify that a justice should disqualify himself or herself when, quote, the justice knows that the justice individually or as a fiduciary or the justice's spouse or minor child residing in the justice's household has a financial interest in the subject matter in controversy or in a party to the proceeding or any other interest that could be affected substantially by the outcome of the proceeding. That means that Clarence Thomas should not have participated in the case involving Trump White House Chief of Staff Mark Meadows' text messages that could have included text messages to and from Clarence Thomas's wife. It also means, according to any reasonable observer, that Clarence Thomas cannot participate in any cases involving Donald Trump, since Clarence Thomas's spouse has a very strong interest in Donald Trump. The new Supreme Court rules seem to have created the perfect carve-out for the Chief Justice's wife to continue to earn millions upon millions of dollars from law firms whose lawyers appear before the Supreme Court. The new disqualification rule says that a justice should disqualify himself or herself if, quote, the justice's spouse or a person related to the justice is known by the justice to be an equity partner in a law firm that appears before the court on behalf of a party to the proceeding, and the court has not received written assurance that the income from Supreme Court litigation is permanently excluded from the person's compensation. That is obviously written specifically, probably written by the Chief Justice, specifically to allow the Chief Justice's wife to continue to derive a massive multi-million-dollar income from multiple law firms, as long as those law firms provide her with a note saying none of her income, which, of course, is also the Chief Justice's income in a joint tax return, comes from Supreme Court litigation. A cover note to the new Code of Conduct suggests that some of these rules have already applied to Supreme Court justices, and that most of the rules are, quote, not new. Joining us now is Democratic Senator Sheldon Whitehouse of Rhode Island. He's a member of the Senate Judiciary Committee, and he is the chair of the subcommittee on federal courts, oversight, agency action, and federal rights. Senator, thank you very much for joining us tonight. You know, Rachel and I were speculating at the beginning of the hour, wondering how you're feeling. Are you feeling victorious, like this is a huge win, or maybe something else?
Well, it was a small win anyway. It's really the first chink in the armor of indifference that these justices have around their own misconduct. So to have that happen is a big deal, although there isn't much new in the so-called Code of Conduct. The fact that they did it represents, I think, a real shift for the court. And now we move on to the real meat of it, and that is, how are they going to enforce it? At the moment, what they've said is, okay, we're going to play by the rules of baseball, but this whole umpiring thing we're not so sure about. We're going to keep calling our own balls and strikes and deciding whether or not we're safe or out at the base, and that's going to have to change.
Well, I mean, eventually, given that these rules are written, you could conceivably have a situation where there's such a pattern of egregious violations of these rules that you could use that as a basis of an impeachment of a Supreme Court justice. Obviously, in the current political makeup of the Senate, that would be next to impossible. But theoretically, impeachment would be the final enforcement of something like this.
It's the final enforcement, but it's also massively inefficient. And that's the reason that every other federal court has a disciplinary process that it goes through, which the Supreme Court could very easily adopt. It's super simple stuff. It's have an inbox for the complaint, have somebody sort out the legit ones from the crazy ones, investigate the legit ones. When you know what the facts are, put them before a neutral person to compare what happened to what's allowed under the rules and report it at the end of the day. That's not complicated stuff. It's what every other court does, and I think they'll get around to doing it sooner or later, and we'll keep pressing them to.
So, for example, on the lower-ranking federal judges, if it is determined after the fact that a federal judge should have recused in a case where the federal judge did not recuse, what would be the remedy for that?
Well, it varies. It depends on the circumstances. I mean, censure is a remedy. In the worst, I suppose they could recommend that the matter be referred to the Attorney General. We impeached Judge Porteous of Louisiana based on a recommendation that came in based on a federal investigation. But I think with this court, with the Supreme Court, the challenge of having lower court justices apply discipline to the Supreme Court is a bit of a hard one to wrestle your way around. I think if the end of the day, what the judges say who are reviewing the conduct is, if this happened in our court, we would not have permitted it. If this happened in any other court in the United States, it would have been a violation of the Code of Ethics. I think that public statement about what the Supreme Court justices are up to would be a very significant rebuke and would dramatically change the behavior of the court.
So before these rules were written, Clarence Thomas has just gotten away with astonishing violations of these rules as they're written tonight, including collecting just direct, massive surges of income, not necessarily through dollars, but through, here, have this very expensive few $100,000 motor home that this billionaire lends him the money to buy it and then never requires him to pay it back. That's exactly the same as handing him a bag of $300,000 in cash, and he got away with that.
Well, not entirely. First of all, our investigations continue both in the Finance and in the Judiciary Committee. The Finance Committee investigation is what revealed that fact. And second, the Judicial Conference is looking into these things. The Judicial Conference is looking into his second round of Harlan Crow free yacht and jet travel gifts, which could result in a referral to the Attorney General to determine if the justice's conduct in not disclosing that was willful. And second, the justice and his lawyers presumed that a recent rule clarification changed the rule so that he said he'd comply going forward. But I've asked the Judicial Conference to answer whether, as they said, it was just a clarification, which means he would have to go back and amend all his previous filings. So that question is still before the Judicial Conference. So there's a lot left to look into, both from Congress and from the Judicial Conference, into Thomas's conduct.
And also that the Finance Committee inquiry on this also will ultimately go to the question of, basically tax. Yeah, I was going to say tax evasion, but I don't want to go. It's not necessarily tax evasion, but it could absolutely require an amended tax return.
If somebody loans you $270,000 and you pay interest on it for several years, and then that individual says, never mind, that's enough, then the principal that you did not have to pay is chargeable on your income taxes as income, and perhaps also as a gift under the gift tax laws. It's over $17,000. So there's an overlay between the tax reporting, both of the donors in these scandals and of the justices who receive the big donations in these scandals. and then the reporting that they have to do as judges. And both merit further inquiry, and we're going to pursue both.
And you know that Clarence Thomas's defense on that would be pleading absolute ignorance of the relevant tax law, as he has done in the past, pleading ignorance of the actual reporting requirements.
Which is weird because there's a place you can go to. It's called the Judicial Conference, and all you have to do is ask. There's a whole committee on financial disclosure that's set up to answer these questions. So you just have to ask and you can get the answer. And when that's available to you and you choose not to use it and you choose to violate the disclosure rules, particularly if you're a Supreme Court justice, I would say, hey, that's on you.
Yeah, and ignorance of the law is just so uncool for a Supreme Court justice. Senator Sheldon Whitehouse, thank you very much for joining us tonight.
Thank you, Lawrence.
Thank you. And coming up, the newest member of the House of Representatives, elected last week, started off as a campaign volunteer for Senator Sheldon Whitehouse. America's newest congressman, Gabe Amo, joins us next.